أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم إن الحمد لله نحمده ونستعينه ونستغفره ونعوذ بالله من شرور أنفسنا ومن سيئات أعمالنا من يهده الله فلا مضل له ومن يضلله فلا هادي له وأشهد أن لا إله إلا الله وحده لا شريك له وأشهد أن محمدا عبده ورسوله. All thanks and praise is due to Allah. We seek His help and His forgiveness. We seek refuge in Allah from the evil within ourselves and the consequences of our evil deeds. Whomever Allah guides will never be led astray, and whomsoever Allah leads astray will never find guidance. I bear witness that there is no God but Allah, alone without any partners, and I bear witness that Muhammad sallallahu alaihi wasallam is His servant and messenger. My dear respected elders, brothers, and sisters in Islam, Assalamu alaikum wa rahmatullahi wa barakatuh. So let me start by saying my apologies for getting here just a little bit behind schedule. I have a 3-month-old son named Rumi, mashallah, and my in-laws are in town for the weekend. And so as you all, are the levels good? Okay. Yeah, it's good. And so, as you all probably know, the kids went back to school this week, and so, you know, one of the things that happens is orientation. So I had to orient my in-laws as to how to take care of my son while I'm away. So I appreciate you all's patience in me getting here a little bit late. Typically, I do this presentation in concert with my law partner, Baig, who could not be here today because he had a scheduling conflict. So typically he does like an introduction and kind of, you know, sets the stage in terms of, you know, what to expect and the parameters of the presentation that we're going to give. But just by way of background, my name is Bukhari Nuriddin. I am a senior attorney with the Baig firm and the head of the firm's wills, trust, and estates and probate practice. The Baig firm was started in 2013 by Mirza Baig, who's a local brother. He grew up in Gwinnett County. His family immigrated from Hyderabad, if I'm not mistaken, in the late 1970s or early 1980s. And so Quorum is a local product that you know, grew up here in Gwinnett County and went to Emory for undergrad, and then he went to Howard University School of Law in Washington, D.C. for law school. How I met Quorum, I also went to Howard University School of Law in Washington, D.C., and when I came back down to Atlanta to start practice, his name kept coming up. This is a brother that you need to meet. This is a brother that you need to meet. So, so we connected, you know, shortly after I graduated from law school, and just kind of kept in contact over the years. And you know, we kind of independently grew and developed in our legal careers. So, Quorum established the Baig firm, like I said, in 2013. The Baig firm is a business law firm. So, you know, if you have business interests that you are engaged in or are seeking to develop, we consult with you regarding how best to structure your business, how best to grow your business, you know, drafting and reviewing contracts. To the extent that litigation comes about, you know, our firm can assist you with respect to that. And over time, the Baig firm has grown and provided additional offerings for the community that we're really proud about. So we also have a family law attorney on staff. So if anybody is going through, you know, divorce or custody situation, we can assist with that. You know, we also have criminal defense attorney, and this past year we brought on a wills, trust, and estates practice. And so I've been diligently working to develop that practice for the Baig firm, but importantly for the Muslim community. You know, one of the things that we have seen in practice is that there's a general awareness of the importance of this, right? There's a famous hadith that says that Rasulullah sallallahu alaihi wasallam at one point said that a Muslim should not let 2 nights go by without, you know, drafting their will and having it with them, right? And the idea behind this is that none of us know the day nor the hour of our passing, right? As Muslims, we have a very strong, you know, belief and faith tradition, right? And, you know, faith without practice is in my opinion, hollow, right? And so it's important to really think about the implications of, all the hard work it is that you're doing to, make a living for yourselves, to take care of your family, to amass assets, right? And then to start to think about the process of what to do with those assets upon your passing, right? And more importantly, to develop a sense of urgency regarding the need for having these plans in place, particularly because we don't know the day or the hour of our passing. And so, we've over time been going around, Kurum and I, over the past 6 months, and we've been visiting various masajid throughout Metro Atlanta, just providing general information about wills, trusts, and estates and probate, and different things that you need to know regarding that. And so, on screen, what we have is a PowerPoint presentation that kind of goes through different aspects of it. And I'm going to try to DJ this as best as I possibly can. So you all just kind of bear with me for 1 second. And let's see. So I want to also thank ICNA for sponsoring this event. And this is a beautiful, lovely masjid. I have the pleasure of knowing Brother Abdurrahim. I'm very much looking forward to sort of giving you all sort of general information about this process, right? So when we think about estate planning, right, we think about the idea of what to do with your property after your passing, right? And a successful estate plan is going to include provisions that allow named individuals to access or control your assets should you become unable to do so yourself, but also a plan around how to go about the process of disposing of your assets upon your passing, right? So generally speaking, when we talk about, this notion of wills, trusts, and estates, what is that, right? So a will is simply a legal document, right, that gives you an opportunity to state who you want to receive your property and under what circumstances, right? It is a document that has certain formalities that need to be followed, right? So one is that you have to be of sound mind, right? You have to have a clear and conscious presence of mind and know exactly what it is that you want to do with your property, right? Secondly, you want to appoint someone to serve in the capacity of what's called an executor or the manager of your estate. This is someone who's going to actually be responsible for managing the disposition of your assets upon your passing, right? And it also gives you an opportunity to name who you want your beneficiaries to be. So interestingly, as Muslims, right, there are certain verses in the Quran, most particularly in Surah An-Nisa, that outline what the distribution percentages should be for your beneficiaries, for the people that you leave behind, in accordance with the Sharia, in accordance with Islamic law. What we try to do is educate our clients about sort of the various disposition schemes that a person can have, right? And allow for you all to make an informed decision as to how you want to go about preparing your estate planning documents, right? So that can take a number of different shapes as we go about the planning process, right? There are certain people that are like, I just want my property to be disposed of in accordance with Sharia. It doesn't matter, who's getting what or how much, right? There are other people that are just not comfortable with that. And so we want to be respectful of people's wishes, right, about how they go about the process. And just the most important thing is to clarify and make people aware of the importance of planning. Whether you plan down, lane A or whether you plan down lane B, it doesn't really make a difference to me, right? I'd like to, and it's really important to me to educate our clients about, the nuances of Islamic or Sharia compliant estate planning. I think that there's a certain amount of elegance to it, and I think that there's a beauty to it. And right, the passage, the scripture that I recited at the beginning of my talk, I like to begin our conversation with that, because Allah subhanahu wa ta'ala, in his infinite grace, mercy, and wisdom, right, he provides us with a blueprint for how we should go about thinking about these things, right? And you know, in practicing this area of law on a daily basis, I see people, you know, fight over the disposition of their property. After their passing, I see the loved ones that they've left behind fight over the disposition of their affairs and of their assets. And if we have an opportunity to plan in such a way that Allah subhanahu wa ta'ala says, all right, this is what it is, whether we thank you, whether we agree with it or not, I think is less important. That's just a personal aside, right? And so, you know, there are typically like three buckets that I like to, you know, place this notion of estate planning in, right? So one is what we call intestacy, right? And as you all see on the slide, when a person dies without a will, he or she dies what's called intestate, right? And essentially what that means is that the state of Georgia has you know, passed statutes and laws. They have laws in place that say this is what is going to happen with your property if you do not take the time to prepare a will. Period. Let me repeat that. The state of Georgia has laws in place that state this is what's going to happen with your property if you do not take the time to prepare a will. These laws are not in compliance with the Sharia. So not only are you, if you don't take the time to do estate planning, not only are you not complying with what Allah subhanahu wa ta'ala has said about this issue, you're also not, you know, providing your own opinion about what should happen with your property. You're allowing for the state of Georgia to dispose of it, right? And so you want to take time and think really seriously about, you know, whether or not that's something that you're comfortable with. Moreover, what we see in practice is that for those that do not take the time to prepare a last will and testament, to do basic estate planning, right? They have to go through a process of what's called estate administration, right? Which you have to go through the probate courts. It's complicated, it's technical, and most importantly, it's expensive. What we found is that people wind up spending more, or I should say their survivors, the family members, their loved ones that they leave behind, wind up spending more money in terms of setting up their estate. When we talk about an estate administration and a person who has passed away intestate without a will, then if the person had taken the time to prepare a will, to develop an estate plan, and to, you know, make the process as easy as possible for their loved ones that they leave behind. And so, you know, we just want to make sure that, you know, there's a certain level of awareness, right, about this issue, most importantly, and what the consequences of inaction, of not doing something about it, are. And so this concept of intestacy is really important. We see it come up on a daily basis. I was working on a matter just earlier this week where, unfortunately, a family, the father of some young children passed away intestate, right, without a will. And you know, the complexity of that matter in terms of trying to resolve it in favor of the family is really, 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 really difficult. I'm not necessarily going to get into the nuances of it, but you know, courts have broad control over how that process unfolds, and there are other people that the court will appoint, particularly if you have minor children, right, to represent their interests. Because what the law is going to say, what a judge is going to say is, you know, if let's say you're a husband and you leave behind a wife and young children, your wife has an interest in your estate, but also your minor children have an interest in your estate, and there's a potential for the interests of your wife to conflict with the interests of your minor children. And so a lawyer has to be appointed, what we call a guardian ad litem. A lawyer has to be appointed, you know, to represent the interests of the minor children, you know, in contrast to the interest of the surviving spouse, right? So we want to avoid some of these complexities if at all possible, because these are some of the things that can run up the cost and increase the level of complexity of resolving your estate after your passing and distributing your assets to your heirs in a way that, you know, you are at peace with, and that comports with your faith and your belief system. Um, so, you know, the second sort of topic or area that we discuss is what we call will-based planning, right? So, what is will-based planning? So, you've already made the decision that inshallah, you're not going to pass away intestate without a will. So, what do I need to think about in terms of actually putting a will together, right? What do you want your legacy to be? Who do you want to have your stuff? What laws or factors do you want to govern that process, right? So, we sit down typically with our clients and we, conduct a consultation where we get some preliminary information from you all, right, about, who your family members are, what your values are, how you want to go about the process of going about this planning process, right? And then what we do is we, structure a set of estate planning documents that meet all of those sort of factors and all of those ideas. And so, interestingly, right, when we consult with our Muslim clients, right, there's already sort of a built-in kind of almost like statutory scheme, right? These are based off of the verses of Surah An-Nisa, right, that sort of allocate who is to get what and under what circumstances, who your beneficiaries are. So there's a couple different terms, and I don't want to get too bogged down in the weeds about this, and I definitely want to leave plenty of time for you all's questions. So I'm going to, touch on one or two other things, and then I'll open up the floor for questions. These beneficiary designations, like I said, a lot of times people will fight over this, right? Oh, this person got more than me, or that person, should have gotten less. And so, what we've done is we have, sort of developed the ability to be able to forecast for our Muslim clients what the beneficiary percentages, right, are going to be under Sharia law, right? So there are a couple different things to unpack there. Number one is under the Sharia, right, you have what's called the wasiyah, right? This is what we call your discretionary bequest, right? Basically, what you can give to whomever you want under whatever circumstances. And then we have what's called the fara'id, right, the obligatory share. So the wasiyah, the discretionary share, is 1/3 of your estate. So let's assume, just for the sake of argument, that you have, let's say, $100,000 as your total estate. Up to $33,333, right, you can donate to whomever you want under whatever circumstances you want, and that's completely halal. It's completely fine, right? The fara'id has to go to what are called your Islamic heirs, right? The 2/3 that's left over has to go to your Islamic heirs under Sharia, and your Islamic heirs are what we call ascertained at the time of your passing. What does that mean, right? So you have family members, right? Because none of us are promised tomorrow. Some of us are here today. Some of us will not be here tomorrow. At the time that you pass, right, your heirs, your beneficiaries are those Islamic those relatives that you have that are practicing Muslim, that are your relatives of a certain level. So typically, what that breaks down to is, you're a husband and you leave behind a wife, you leave behind, a son and a daughter. All of those are your Islamic heirs. Those are your direct beneficiaries. What we're finding in practice is that sometimes we have Islamic heirs that are of the older generation, right? So, there is guidance, right? What we call, fatwas, right? Or jurisprudence about this, fiqh, that, stipulate that, your parents' generation is entitled to an obligatory share. Some people are comfortable with that, other people are not, right? And so this starts the brain juices flowing, this gets the conversation going, and the idea is to plan an estate plan that works for you. It doesn't matter if it works for you and doesn't work for you. It doesn't matter if it works for you and doesn't work for you. What are your goals? What are your values? What are your beliefs? And how do you want to go about putting them down on paper so that we can avoid this idea of intestacy, right? Passing away without a will and letting the state of Georgia determine who is to get what from your estate and under what circumstances, right? So that's what we call will-based planning. There are other documents that we also include in that planning process that help facilitate care and attention to your financial affairs, right, during your life, but in case of incapacity as well. This is what we call essential estate planning, right? Just the foundational documents that everyone needs to have in order to lead a good life, knowing that your estate has been planned for, and that there's not going to be a lot of challenge and difficulty, once you pass away, and the courts are not going to impose their opinions and beliefs on how your property should be disposed of at the time of your passing, right? Interestingly, and just as a brief aside, intestacy, you have to go through the probate courts. Will-based planning, you still have to go through the probate courts in order to have someone appointed as the manager of your estate, whether it's what's called an estate administrator, if you're talking about intestacy and you've passed away without a will, or what we call an executor or executrix, right, if it's a female, if you have a will, right, so the will has to be submitted. Under both of those scenarios, right, scenario A, scenario B, you still have to go through the probate courts in order to transfer your property in accordance with Georgia law, right? There's a third category, what we call trust-based planning, right? And what a trust is, let me see if I can get to this. This is a good one. So what a trust is essentially a separate legal entity, right, that is created during this estate planning process that we go through, right, that stipulates exactly how you want your property to be disposed of, both during your life and after your passing, right? So we have different types of trusts like you see. So you see lifetime revocable trust, lifetime irrevocable trust. There's different types of planning and different advantages and disadvantages of all of these different types of estate planning tools. The most important thing that you need to understand about trusts are that, first and foremost, that they sort of dispose of your property in a completely private way. So there's no need to actually have to go through the probate courts upon your passing, because as part of the planning that we do, if we're talking about trust-based planning, we are actively transferring your property over into the trust, right? So the property is already owned by a separate legal entity. That legal entity determines what is to happen with your property upon your passing, so there's no need to actually have to go through the probate courts. That's the most important thing. There are different sort of tax ramifications depending on how sophisticated we get in terms of the trust-based planning. And in our experience, folks that elect to do trust-based planning tend to have actually a less significant legal spend. It's a little bit more expensive on the front end, but overall they wind up spending less because they're dealing with this all at one time, as opposed to not dealing with it at all, or dealing with it in a limited way if we're talking about will-based planning, and still having to go through the probate process. So I will sort of stop my remarks there, my formal remarks there. I want to open up the floor to questions, and I'm sure that other things will come up as we continue the process.
I have two questions.
He wanted the microphone.
Assalamu alaikum.
Wow.
I have two questions. First question was when you said about the trust, and you said the trust manager or something?
Correct. So the term of art is what we would call a trustee, right? So there are different roles. So let's say you wanted to establish a trust. You would be called the settlor, or the founder of your trust.
Okay.
You would also be the trustee, the initial trustee or manager of your trust. You would also potentially be a beneficiary of your trust, right? Keep in mind, you're creating a separate legal entity that's going to manage all of your assets, all of your financial affairs. And you can also, during your lifetime, be a beneficiary of that plan, right? So continue with the question.
So, let's say I'm making a trust for my assets, and I'm no more longer there. So I can make my beneficiary to be one of the person to be a manager of the trust.
Correct. Yes, you absolutely can. You can have a provision in your trust that states that at your passing, you want person A or person B to be what's called the successor trustee of your trust, right? So you want to think about, you know, who you want to serve in that role, and you don't want to just have it be like, you know, your spouse necessarily or your oldest child necessarily. You want to think a little bit more deeply and say, you know, maybe there's a person that has, you know, really sound money management or sound critical thinking skills, or, you know, is well versed in, maybe, you know, different aspects of finance in terms of how to preserve, you know, the assets that are in trust and grow them for the benefit of everybody that's a beneficiary, right? So, you know, we think about these things, and it's an active conversation that we have, you know, when we do your planning, to identify who's the best fit to serve in that role after you're passing and after you're here. I mean, after you're gone. Excuse me.
Thank you, my brother. I appreciate it.
Any other questions from anyone?
I do have a Assalamu alaikum.
Wow.
Jazakallah khair, you offering all that.
Right, yeah.
On that, can you just explain a little bit difference between irrevocable and revocable trust, please?
Yeah, so thank you for the question. The question was, what is the difference between a revocable and an irrevocable trust? So basically, a revocable trust is a type of trust that is essentially open-ended, right, during your lifetime. So what that means is that when we do the planning, like I said, you know, we actively transfer assets into your trust. If it is a revocable trust, you can put assets into the trust, but also as trustee of your trust, you can actively take assets out of your trust, right? You can sell property, dispose of property in your trust if it's revocable as you see fit. As you see fit. The difference between a revocable trust and an irrevocable trust is logically, right? This makes sense. With an irrevocable trust, once you place property into an irrevocable trust, it is there. It's stuck. You cannot, you know, sell that property or otherwise dispose of that property, right? Except under very, very limited circumstances that have significant tax implications, you know, if you should decide to do it or need to do it. So an interesting example, I was driving to work the other day. Rupert Murdoch, I don't know if you all are familiar with this person, Fox News or Fox, owner of Fox Corporation. He established an irrevocable trust, right, for his wealth, right, and the beneficiaries were supposed to be his children. And so he has like 4 children, and his personal wish was that he wanted the oldest child, who most closely aligns with his political viewpoints, right, and ideology, to take over the business, to be the manager of the business after his passing. His other children, you know, do not want that person to serve in that role, right? And so what Rupert Murdoch has decided to do is, even though he established an irrevocable trust, right, he is actively litigating in a court as to try to go about sort of terminating that trust or ending that trust or changing that trust, right, to more comply with what his wishes and views are, right? This is sort of an outlier situation or scenario, right? And rest assured, I would imagine he's spending a significant amount of money to, you know, fight in court about this, right? So the idea is that with an irrevocable trust, make sure that this is property that you want to be in the trust and that you want to be managed by the trust, both during your life and after your passing, right? Because it's very, very difficult to unwind that, and there are significant implications to that. The last thing that I'll say about revocable versus irrevocable is that there are actually certain tax advantages to establishing an irrevocable trust under certain circumstances, right? If you're charitably inclined, right? If you want to give a certain amount of your estate away, you know, both during your life, but more importantly after your passing, there are ways and types of trust that can be structured, right, to essentially manage that process in a very tax advantaged way. So I'll leave it at that.
Thank you. Actually, the both trusts, irrevocable and revocable, you mostly pushing towards when somebody passed away. But they're beneficial if somebody is also alive.
Correct.
So if somebody has an irrevocable trust and put all his assets into that, and he or she is a trustee, so they cannot remove any assets from there, right? That's what you're saying?
Generally speaking, yes. And so there are ways to go about doing that, right, that allow for a person to be a beneficiary, but also have essentially limited control over how, like, the assets in the irrevocable trust are managed and sort of the day-to-day operations of the trust, right?
But as a trust, trust can sell that property and bring that money or whatever the proceed into the trust, right?
So if we're talking about a revocable trust, yes.
Yeah.
If we're talking about an irrevocable trust, no. Now, selling is different than, let's say investing, right? So, these are terms of art, and these are sort of details that, are probably beyond the scope of our talk today, but definitely things to think about, when we go about, planning and trying to figure out what would be the best type of estate plan, option for you.
Thank you. Just last, I know there's a lot of questions over there. So trust is a shield between anything happen to the person, right?
Correct.
Like something that says somebody lawsuit personally, so they cannot reach to any of their assets if the properties or assets are sitting in a trust.
Yes, there are certain scenarios where you can conduct your estate planning in a way that shields your assets from creditor claims.
Okay. Thank you.
You're welcome.
Assalamu alaikum.
Wa alaikum salam.
To his last point, I think in terms of lawsuits, I think irrevocable trust is where you would want to generally put your thought towards, right? Because in a lot,
go ahead.
I've heard that in an irrevocable trust, then in case of a lawsuit, they can't get to your assets.
Yeah.
basically.
So the question is about sort of limiting personal liability with respect to your assets, and how to think about that, in conjunction or in concert, in tandem with your estate planning, right? So there are a few different things, right? Number one is that, when you think about these things, it's a fluid situation, right? There are a number of different factors that are at play. A lot of folks in our community, they tend to be business owners, right? And so, one layer, if we're talking about limiting liability, right, is operating your business not as what we call a sole proprietorship, right? Which means basically I just want to start a business. I'm gonna, open up a store, and it's gonna be, Hussein's, Zabiha or whatever, right? What you want to do is have a first layer of limited liability by establishing some form of a business organization, like a limited liability company, to shield, right, your personal assets from creditor claims, right? If you're running a business, right? A second layer of insulation, right, that we highly recommend, and there's some debate about the permissibility of this, right? But but the notion of having a certain amount of insurance, right, in place to also have an additional layer of insulation from creditor claims. A lot of times, if we're talking about from a litigation context, right, someone that's trying to come after your assets has to make an election as between trying to go after insurance proceeds, right, the value of your insurance policy, or, right, assets that you may have in the business, right? You only get one bite at the apple. You can't get both. Then a third layer of insulation is to think about this concept of limited liability and creditor claims, right, against your assets within the context of estate planning. And how we do that is whether it's a revocable trust or an irrevocable trust, right, establishing it in a way that, like I said before, sort of takes all of your assets out of your, sort of person, right? And places them in some form of a trust instrument, right? And, does so in a way that has an additional layer of shielding from liability. So sometimes that may be funding a trust with, certain insurance products. Or, to your point, right, establishing an irrevocable trust, but doing so in a way that, you are serving as a beneficiary, but you're not necessarily the trustee of your trust, right? That way, you have very limited control over how your trust is being managed, right? But, ultimately the trust is, because it's irrevocable, right, it is, providing that additional layer of shielding from creditor claims. So these are different things that we think about when we go about the planning process.
I just have one more question.
Sure.
And this is sort of like switching gears, completely coming down to a whole different level
Yeah.
of conversation. And that is, if you are not a business owner, just a common person, just a little bit, you own a property, home, and just limited amount of assets. And, when you think in terms of its executor, going back to executor and probate, online services nowadays are obviously, such as LegalZoom, they offer all kinds of services, as you know, and generating online bills as well. And in that process, you generate the will, and then you're asked to go to along with witnesses to a public notary. And you go through that process, and you get all the signatures, notarized and all that, and pretty much, at that point you think that, okay, all's done. You give a copy to them, keep a copy elsewhere of the will, and that you're pretty much done from that perspective. But is that true, or in that situation you're still required to go to the court and still kind of come up with an executor and all of that? I mean, just trying to figure out, is it that simple as the LegalZoom will try to make it?
So, I have my reservations with respect to, so the question generally is, is it advisable for a person to engage in what we call self-help, right? The legal term would be pro se, legal advice, right? In terms of trying to prepare an estate plan through a service like a LegalZoom, right? And I would also, I would be remiss if I did not sort of, in the same vein of question, right, bring up there are certain will templates, right, that are online that have been developed for Muslims, right? And let me first start by saying that may Allah reward anyone that has tried to provide a beneficial service for our community. I can remember not even 10, 15 years ago, people weren't even having these conversations, right? There are lots of people that were passing away without a will and not knowing what to do, in these circumstances. So even just the evolution of our awareness about the importance of doing this is, I believe, a benefit, right? And so I want to sort of set the table, by saying that. Now, obviously, if you're going through a LegalZoom, right, scenario, LegalZoom is not going to be able to give you, advice about, what the Sharia says about how you should go about the estate planning process. So, if you're fine and you're comfortable with that, I think, if we're talking about top level down, right, then, having a will is always going to be better than not having a will. And I would never tell you, you should steer clear of LegalZoom if, that is, what your heart is speaking to you, and it's the preferred option that fits within your budget and provides you with the type of planning that can provide you the peace of mind it is that you're seeking, in terms of thinking about or going about the estate planning process. what I try, there are a couple different analogies that I kind of liken it to, right? And the first is that in the medical context, right? If you had, let's say, an abscess on your gum, or you had like a big, bulge on your shoulder one day you woke up, right? You would not, right, go into the kitchen and take a knife and, go and start cutting at your back, right? You would go and you would see a doctor, right? Or you would go and see a dentist if you have abscess on your gum line, right? So, we have spent significant time, not just in our legal education in law school, but also on a daily basis, right? Keeping, up to speed on both the developments under Georgia law, in terms of what we call fiduciary law, but also doing a significant deep dive with respect to what are sort of the sort of generally held, generally accepted, but also minority positions as it pertains to this notion of Islamic-based estate planning or Sharia-compliant estate planning. So we believe that like we are the firm that's best suited, right, to advise our community about these particular issues, and we would invite everyone to come in for a consultation to have talk about these issues as it pertains to your particular situation or scenario. And I'll sort of end the my answer with this is that I don't know if you've ever had like the benefit or the opportunity to have like a custom made suit, right? There's a difference between going to like Macy's or going to like Marshall's and finding something that kind of fits you a little boxy, right? Versus going to someone who this is what they do day in day out, right? This is their profession, and they can get it to you so it fits you like a glove, right? And that's the idea here is that LegalZoom is going to be a one size fits all, right? If you were to download a template from a masjid's website, right, that has a disclaimer that says you should consult with an attorney, right? It probably means you should consult with an attorney. What we're saying is we're attorneys, we're doing this, you should consult with us because we'll get you in the best situation.
That's a fair point, and I could truly appreciate that. It was just, my question was really a technical one, more so than, technical in the sense that a lot of people start off probably nowadays, especially who haven't seen seminars or really thought about going to attorneys like yourself, or law firms, and having wealth of information online available, and promoters of their services like LegalZoom, for instance. People who've not thought about getting a will, like, oh, everything is there, and even from a Sharia standpoint, if you have gathered enough information yourself, you can put that in the templates and all of that and generate. Not necessarily.
Can you? I don't know. I've like I said, I do
select percentages.
Well,
and so forth.
listen. I do this on a daily basis.
Sure.
I've had people come to me, right, and ask me to work out these percentages for them because they've gone to the imam of their local masajid and they cannot do that math for them, right? There are layers to this. And so what I'm saying is that the nuance associated with it, it might be worth the cost of going to see someone. So your point is well taken from a, and like I said at the outset, right? Having something in place is always going to be preferred than not having something in place. But it's what you have, the quality of what you have.
Absolutely, and I could
really
appreciate
speaks
that.
to
Right.
Your level of commitment to this process, and how you want to how easy or difficult you want the process to be for the folks that you wind up leaving behind.
And that's very valid. And coming to that technical point that I was looking for the answer for, is the executor. Like, for example, people may not know, going back to the original point, okay, you've created this without consulting an attorney, downloaded, you think you've got the percentages right, whatever the case might be, but now you're at a point, you pass. Your document was signed in front of a
notary,
and now your family member, along with that copy, just tries to execute that. is that sufficient? Does that suffice, or do you have to still get an executor, or or go through the courts
So
in
you're-
advance while you're still?
No, so you can sort of put a copy, or I would say deposit with the court a copy of your will, right? Is it necessary? No. When an executor goes to probate your estate, right, there are a series of steps that that person is going to have to take. Not the least of which is to provide the original of the will, right? And so, there are certain, like I said, nuances that are associated with the process of serving in that capacity of executor that you want to take time to think through the implications of, right, prior to appointing someone to serve in that very important role, and to probably take some time to consult with someone to sort of walk you through what that process of probate is going to look like for the person that you've entrusted with the role of executor. Yes, sister.
Hi, assalamu alaikum.
Wa alaikum salam.
I appreciate the considerations that you're sharing with us that we should be keeping in mind. I'm also, you might have covered like what is Sharia recommended before, but I came in late.
Mm-hmm.
But I was wondering how that applies to the revocable and the irrevocable trust, how it can be Sharia compliant,
Yeah.
and also like for a lay person, kind of like middle income, what is recommended? Like what are the assets that are going in each trust, and like how is it being sliced and diced and like allocated? And yeah.
Okay, so these are excellent questions. The first question had to do with, I may ask you what the second question was, but the first question had to do with, this idea of, the extent to which trust-based planning is Sharia compliant. What sort of trust instruments are Sharia compliant, or how to go about thinking of Sharia compliance in terms of trust-based planning is probably the best way to phrase the question, right? It's an excellent question. The general idea, right, is that when we're talking about trust-based planning, we are talking about a end-to-end solution regarding the disposition of your assets, both during your life and after your passing. When we're talking about Sharia compliant estate planning, we are talking about the importance of establishing some plan to transfer your assets to your beneficiaries upon your passing, and to do so in a way that happens without delay. That is the most important critical aspect of it. There are different types of trusts that exist, right, that will delay the transfer of assets from one beneficiary to another, right? Typically, like you may have, like, let's say a husband, a wife, couple kids, right? You can set up certain types of trusts that upon the passing of the husband, right, all the assets transfer to the wife. That is not what we would call Sharia compliant, right? Because your beneficiaries in that scenario would be your wife and your two children, right? So your wife and your two children would both have an inheritance right in all of that property, and that property should be distributed to those people without delay, right? So we plan along those lines, right? Trying to, make sure that we enjoy the benefits of these different planning techniques that are in place without running afoul of what our faith tradition says about who should get what and under what circumstances and at what time. And so that's the best way that I can kind of describe that. The second question, if you could repeat it.
Can you hear me? Okay. So basically, like for an average middle income kind of person or family, what decisions should we be making to put into the revocable versus irrevocable? Like, how would an average person kind of like decide what's most beneficial?
Okay. Define average or middle income.
Like, I guess I'm not asking just for myself, but like, yeah, like,
Yes.
Can I add one question
Sure.
to it that would probably...
Yeah.
Is there a dollar amount for a person
annually or wealth where he or she needs to think about making a will or a trust.
Yeah.
So in other words, if someone has an average income family with one house, two cars, $10,000, $20,000 in the bank account or savings, do they need to go and make a will or a trust, or is there a dollar limit where they should think about it, or they should just go ahead and do it anyways?
Yeah. So thank you for that. Thank you for that. Thank you for the question as well, sister. I was just always curious. I was messing with you a little bit, but I'm always a little curious as to what is reasonable or what middle income is or average is to different people. I think that there are different answers to that depending on who you're talking to. The general idea is that everyone should have a will. I don't care if you have $1 in your bank account or you have, $100 million in your bank account. Everyone should have a will, right? That will is not, when we're talking about will-based planning, right? It doesn't matter that at the time that you established your will that you have $1, right? It matters as in terms of what assets do you have at the time of your passing, and that can change wildly from the time that you prepare your documents to the time that you ultimately wind up passing away. So we shouldn't worry about or get too bogged down in terms of do I have enough to have a will? Everyone should have a will, period, full stop, okay? Now, when we talk about trust-based planning, there's an aspect of trust-based planning that you're also going to have, a will as a component of that, right? And that's called a pour-over will, and essentially it directs any property that you have not actively transferred into your trust during your lifetime already to, by operation of you passing away, to go into your trust. So typically, we're talking about anywhere from, it's hard to say a ballpark, but because some people find the private nature of trust-based planning far more attractive than what their net worth might be, right? So there's not a one-to-one allocation. You may have a house, couple cars, right? Let's say a 401k, whatever, right? So the overall value of your estate may be $250,000, $300,000, $400,000, right? Does that mean that you should not have a trust, right? I don't know. It depends on whether or not you find it important to put a plan together in place that for a fact or without a shadow of a doubt that is going to allow for your loved ones that you leave behind to not have to deal with the probate courts. Sometimes there's a built-in value associated with the privatization of the planning that people place a financial premium on, and tend to want to engage in trust-based planning as a result of that. But the general idea is that everyone should have a will, regardless of whether you have little or you have much.
Assalamu alaikum wa rahmatullahi wa barakatuh. I just want to ask about the will or the trust in the United States, if it covers property and possession overseas.
Yeah, so this is an excellent question. It deals with, to the extent that you have international property or assets that are housed overseas, how do you think about what to do with that, right? So, this is something that comes up fairly routinely, particularly in our community, right? Folks have, come here from different countries or have relatives that live in different countries. They may have, property interests or assets in other countries. How do we go about thinking about that in terms of trust-based planning, right? It's not typically going to come up in the context of will-based planning, but if we're talking about trust-based planning and we're talking about actively transferring assets into the trust, right, there are different ways to kind of go about doing that. So number one, what we're gonna do is, let's say, a lot of times what people's sort of largest asset that's held overseas is typically going to be in some form of real estate or property, right? So a lot of times, what we like to do is consult with a local attorney, right, in that country to receive guidance from them in terms of what the most effective and tax advantageous way is to go about transferring that asset into a person's trust estate, right? So sometimes that may be, establishing a legal entity, right, to own that property, and then the person, or I should say the person's trust, right, has an ownership interest in the business that owns the property, You see what I'm saying? And so there are ways to structure these transactions to afford a person to be able to sort of loop their their property that's held internationally into their trust instrument that is prepared here in the United States and is governed by U.S. law. The other factor that comes into play, but in very rare circumstances, is the extent to which there may be like treaty issues or a reciprocity in terms of laws between a recognition of the validity of laws between the United States and any particular country, right? So if you're Russian, right, and the United States has a some form of hostility, political hostility with that country, it may make it a little bit more difficult to engage in that type of planning. So these are all factors that we would take into consideration.
But another thing that you mentioned that like for taxes issues, normally that the property or the possession they already made by money that been taxed already. Does it like
anytime a piece of property is sold, keep in mind like there's an active transfer. Like this is what differentiates trust planning from will planning, right?
correct?
Trust planning, there's an active transfer of property from one thing to another, right? That allows for the privatization that I was just talking about when we talk about trust planning to actually have effect, to actually be worth something. That transfer of property, if we're talking about an international asset, typically a real estate, right?
Correct.
That the transfer of that asset from one entity to another, regardless of what it is a taxable event in and of itself, right? There's going to be some form of real estate transfer tax that is going to happen, right, or is going to be required when we're talking about essentially selling, right, or transferring that asset from one entity to another, right? And so the reason why we sort of try to incorporate local counsel as much as possible is they'll know the nuances of Indian law or Bangladeshi law or Moroccan law, right? That say, all right, well, this person probably would be better served to do it, in their individual capacity, or to establish an LLC, or to do it as some form of a charitable, transfer, right? And so we discuss those nuances as part of the planning process.
Thank you so much.
So I heard some things that you spoke about from the aspect of having multiple trusts. So one scenario that came to me was that I understand when it comes to a person that might have multiple assets and they have a irrevocable trust, that if they plan on in the long run donating that land, that it might be from the tax perspective, it might be beneficial. But from the average, like we were speaking earlier, from the average person's perspective, do you see or have you seen scenarios that you could explain maybe to us where having different revocable or irrevocable trusts at the same time might be beneficial?
Yeah, so typically, what I advise is for each individual to have, a trust. If we're talking about trust-based planning, typically, these are married couples, right, that have children. There are certain assets that a person has that sort of are not subject to the probate process. Let's start there, right? So, for instance, life insurance is one of those things that passes outside of probate, right? If you name someone as a beneficiary of an insurance policy that you have, that person does not have to go through probate. There's nothing that has to happen. They receive the value of that policy at the time of your passing. Similarly, retirement accounts are something like that. You can name anyone or anything that you want to be a beneficiary of those policies, right? So what some people decide to do is they decide to establish revocable trust, right? So you have husband revocable trust, wife revocable trust, right? And as part of that planning, husband has 401k, the husband then designates his trust to be the beneficiary of his 401k. So that there's everything is going into one pot. It's not a piecemeal thing. It's not you're allocating your retirement account to go to your wife, but your insurance is going to your trust. Like, we try to make it as comprehensive and as elegant and as simplified as possible. As part of that process, if we're talking about a person's average assets, right, Typically their house is going to be their largest asset. There are certain types of title to property, how property is owned, right, that can make or break that process. If we're talking about will-based planning, right, what you want to see, the magic words, right, are going to be typically if you're owning property jointly as spouses, and we highly recommend that our community members strongly consider owning property jointly as spouses, right? This is very, very important. Probably the last 10 estate administration matters, right? People passing away without a will, right? The property has been held solely in the husband's name. The wife has no title to it, and it makes the resolution of that situation very, very difficult for the wife and the kids that are left behind. So the magic words, right, would be to have your property titled, and this is separate from whose name is on the mortgage, right? As long as the mortgage is getting paid, the bank is not going to care, right, whose name is on the mortgage. The deed, like if we're talking about monopoly, right, the deed is what matters, right? You want to have both your husband and the wife, both spouses' name on that deed as what's called a joint tenancy with right of survivorship, period, full stop, okay? This way, by operation of law, if you do nothing else in terms of your estate planning, even if you don't have a will, right, that property will pass to the surviving spouse by operation of law at the time of your passing. This is what the term right of survivorship means. Whoever is the last person living gets the ownership of it, right? So that's under an intestacy scenario, also under a will-based scenario, right? You're not going to have to necessarily, go through probate, right? Sometimes you can have a will and have your estate planning done in such a way that, it sort of prevents, the need for having to go through probate at all, right? Because you've already disposed of all your assets, so there's nothing necessarily to probate, right? That doesn't mean that you should not have a will. You should definitely have a will. It's just sometimes you may not necessarily have to go through the probate if you've planned, well. Under a trust scenario, your thinking is similar, but the ownership, because it's being transferred from individuals, right, to these separate legal entities, your trusts are then going to cede to or have the ownership of the property. So it's the husband's revocable trust and the wife's revocable trust as joint tenants with right of survivorship, right? That way, by operation of law, right, at the passing of the first spouse, right, their trust becomes irrevocable. The surviving spouse's trust may still be revocable, right? But the property, the asset, the underlying asset passes from the husband's trust to the wife's trust or some other distribution scheme that fits within, your faith tradition. So sometimes multiple trusts in one sort of large estate planning engagement is required. Oftentimes, we can plan the provisions or how property is to be distributed within the context of, sort of essentially matching reciprocal spousal trust planning, if that makes sense.
No, that answered my question. Thank you.
I have a general question.
Hold on, sister, let's get a question from the sister.
Okay, assalamu alaikum.
Walaikum salam.
I kind of missed in the beginning, so I'm sorry if you already answered this question, but it's kind of a two-part thing. Mm-hmm. One being, say both husband and wife are to pass away without a will. Mm-hmm. Is it smart to have an adult child also on that deed? Is that possible? Or if all kids are minors, how would you go about it in that situation?
Yeah, so in a situation where sort of spouses do not have a will, they have property, and they pass away, like let's say the classic example is a simultaneous death scenario, right? They're on a vacation somewhere, the plane goes down, what's to happen? This raises another very, very important issue, and I'm glad that you brought it up because we didn't touch on it previously, is this notion of if you have minor children and you're in that scenario, what happens, right? Under certain circumstances, right, the state will come in and intervene in that scenario if you have not made a provision for who you want to serve as guardian, legal guardian of your minor children. That's a really, really important thing to keep in mind, right? So, you know, it also is something that you can sort of outline in your will, right? Who you want to, you know, be a legal guardian. A lot of times there'll be like close family friends or, cousins. Sometimes, folks may have folks that, live in another country that they may want to have. So you may want to have like, local, guardian just for temporary purposes until such time as, the person that you want to come and have the property or have the legal guardianship of the children can get there and can handle that. So that's another argument as to why it's so important to have a will, right? To your point, to your question, is it advisable to have an adult child as a joint tenant on property with parents who don't have a will? Yes and no. It depends on the situation. This notion of joint tenancy, it's not necessarily a cure-all, right? It's just sort of like one tool that we have in our toolbox to make sure that a person's affairs are comprehensively attended to. So I think the best answer to your question is I would need more information, in order to really give you the type of advice it is that you may be seeking.
Are you available after Salah for question and answers?
Yeah, like I said, my in-laws are in town, so I kind of have to get back.
Oh, that's important.
Yeah, I have to get back to. I have a 3-month-old, so I have to kind of get back to him. But I'll stick around for a few minutes, inshallah, after Salah, and
So
if
we have
anyone
5
has
more
any
minutes.
other questions.
Any other questions from anyone?
I have one last.
Yeah. Yes, sir.
In a nutshell, Sorry, one last question. In a nutshell, can you give us a real life scenario without, holding you accountable for this? Is if someone without a will passes, what kind of dollar amount, court implications, roughly, as opposed to a person with a will, and as opposed to a person with a will and a trust-based will?
Yeah. So this is an interesting question. What it touches on is the sort of overall costs, legal fees that are associated with this process, this area of the law. So if we're talking about an irrevocable scenario where a person has passed away without without a will, right? And estate administration is required because they have property, because they have assets that now need to be disposed of in some way, right? That's going to add significant complexity, right, to the legal engagement, right? So, let me sort of talk about it from a process standpoint. That's typically how I look at it, right? Everybody that walks in the door, everybody's situation is a little bit different. So what we do is we take the time, we sit down with our clients or our potential clients, right? We get a sense of what their legal issues are and what the factors are associated with that. And then naturally what will happen is issues will come up as a result of that, right? This is important at the outset because it helps us develop what we understand to be the scope of representation. Everything it is that we're going to be doing for you, whether it's based in intestacy or will-based planning or trust-based planning, right? So if we're talking about probate, in an intestacy scenario, you're looking at probably an initial fee of $3,500, right, just to kind of file the application, right, for letters of administration. Depending on the complexity of the actual administration of the intestate estate, it could be an additional $10,000 or more on top of that if we're talking about intestacy. If we're talking about will-based planning, right, our firm charges a flat rate of $1,500 per individual, $2,500 for a couple, a married couple, to do will-based planning, the essential planning that I described at the beginning of our talk, right? If a person has done really, really well in terms of their planning and the disposition of their affairs by having appropriate, beneficiary designations that fit their scenario and fit their circumstances that they're, at peace with, that may be all that a person needs to do, right? You may, want to look at, like I said, how your property is titled, right? The deed of it. But beyond that, you may have no need for probate. You may have a need for a limited probate, right? So it's not going to be anywhere near as expensive as what would happen in an intestacy scenario. And then under trust-based planning, right, there's a higher upfront cost. Typically, our planning, if we're talking about trust-based planning, starts at around $5,000 and can go up from there depending on the complexity of the planning that a person, wants to have. So, we just encourage folks to come in for a consultation. We charge $250 for our consultation. Typically lasts about an hour. And essentially what I'm doing for you all, right? I'm doing the same thing in a very, targeted individual way based off of your particular factors during that consultation. And then we develop the scope of representation from there. And then we go about the engagement from there.
All right. Thank you. Last question, and then inshallah we'll break for Salah. So Sharia compliant, you've heard that term today over and over and over. Just know that Sharia is not one thing. It's not like something that's concrete written down. There's difference of opinions on certain matters. I'm not saying I'm an expert in this, so I wanted to ask you, when you say Sharia compliant, what exactly do you mean, and where do you find some of the difference in opinions?
Yeah, so this is an excellent question, and probably the best place to kind of end is that, because there are different sort of schools of thought in terms of jurisprudence in Islam, you have different scholars that have interpreted the Quran and the Sunnah regarding this issue in different ways. So if you are, let's say, a Shia Muslim, right, your interpretation of what the Sharia says about this particular issue is going to be a little bit different than if you are a Shafi Muslim, or so these are some of the things that we take into consideration. So when you say what are some of the things, the factors that you bring in, it really is what you bring to the table, right? It is what is your worldview, what is your belief system. And then we sort of delve into what the scholars have said about that particular, belief system, right, about this particular issue. And then, we have an active discussion about that. So like I said, there are some, people who come in and they're like, I'm just Muslim and that's all. And I want to leave, my property to my wife and that's that. And I'm like, okay, that's cool. That's what we're going to do. There are other people that say, all right, well, I have this scenario and I want to reallocate certain, property. I have, a couple different daughters. I've got, a relative that's not Muslim. How do I incorporate that person? So everybody's situation is a little bit different. We factor all of that in terms of, how we go about advising our clients with respect to this
Jazakallah
issue.
khair. Yeah, so I wanted to make sure everybody understands that Sharia is not one thing. So there could be some difference of opinions. So definitely do a little bit of research and those kinds of things. So alhamdulillah, jazakallah khair for this wonderful, very engaging presentation. I'm sure there's tons of questions. Sometimes we don't even know what to ask and where to begin. So any closing comments? Where can anybody begin? Just come for a consultation?
Yeah, so you can find us online. I'm really bad at these plugs, but you can find us online. Our website is
You did already plug.
our website is Baiglaw, BAIG, baiglaw.com. And you can find us online, our website, our socials. There you go. That's it. Wa yakum.
Jazakumullah khair.
Wa yakum.
Okay, assalamu alaikum.
Wa alaikum salam.